時間到。
It's the appointed time, and we have a quorum. Please ask the administration to come in to join us. Any declaration of interest? Let me start first. Under Rule 83A, I declare information about those related to travel industry. I am a paid director for one agent, and for 9 of them, I consult an honorable consultant and director. And you'll find details of the information in paper number 849/01 of 2017-18. I will dispense with the introduction. We've had several meetings before that. Let's start. You have given us a response paper. Please take us through it. In relation to members' inquiries, we have issued a response paper. There are 3 major topics. First is the requirement to deposit guarantee money. Members asked that for existing travel agents, under the new regulatory regime, they are required to deposit guarantee money. What would happen? Usually 2 things will happen. First, when the fine reaches a certain level, when the number of sanctions has reached a certain number, then the travel agent is required to deposit guarantee money. That will be the same as a newly registered travel agent. First is 250,000 for the first tier, unless the fine level or the number of sanctions has increased, then it will be increased to 500,000. The way it's paid is a bank guarantee. As we have explained in the last meeting, details of payment of bank guarantees, say for example, time limit, the Travel Industry Authority will prescribe it by way of administrative measures. Second, requirement to appoint authorized representative, AR. Members asked that what is the difference between just a travel agent and an AR when it comes to criminal liability. If a travel agent commits an offense, of course, the travel agent, that is the agency, will be liable. If it is a firm or a company, and if there is evidence showing that the offense is committed with the consent or connivance of the AR and is attributable to any neglect on the part of the AR, then under clause 166(3), 1 or 3, depending on whether it is a company or a firm, the AR is also liable. A member asked whether AR can be a company secretary. In paragraph 5, you will find the response. An AR can come from directors, managers, company secretaries, or controllers. ARs can come from the management personnel or controllers of the travel agent to ensure that the AR has a general understanding of and commitment to the travel agent business concerned. We have taken reference from Cap 622 Companies Ordinance in relation to the interpretation of officer. Under this interpretation, apart from directors and managers, company secretaries are also officers, so company secretaries are not someone of a lower rank. We think that directors, managers, company secretaries, controllers being ARs is an appropriate arrangement. Some member asked about the relaxation of requirement of management experience imposed on an AR. Some members concerned that, it might be relaxed too much. We think that the AR is responsible for the management and operation of the travel agent, so it should be subject to sufficient supervision. The AR has to ensure that the operation of the travel agent complies with all rules and regulations. So the AR will have to have management experience, otherwise it will not be conducive to safeguarding consumers. When we put in place the arrangements, we preserve flexibility. Someone who intends to carry on travel agent business meets the qualification requirement, or if the business partner does so, then the person can himself or be the AR or ask the business partner to be the AR. Recently, the industry has put in place qualification framework. This is to ensure that there will be sufficient manpower with the right qualification for the industry. So we have taken into account the need to regulate the industry without stifling or obstructing those who have an interest to join the industry. Any questions in relation to this response paper? If not, we will go into clause by clause. We will take up from where we left off last time. It was part 9. Last time, part 9. So it's part 2 is miscellaneous, is 33. That is in relation to registration fee for mainland inbound tour group. This is division 9 of part 2. It stipulates that licensed travel agents who carry on mainland inbound tour group business must, for each inbound tour group, pay a registration fee. This will be stipulated by way of subsidiary legislation, and the payment will have to be made to the travel industry authority. Any questions? I would like to ask about the fees. It will be prescribed by way of subsidiary legislation. If there are adjustments, it will also be done by way of sublet, right? Well, we now say that we draw the line of 40. Under that is 30. Above 40, $60, and we will start from there. It is rather complicated because there will be many different levels of fees. In relation to registration fee of mainland inbound tour groups, this is the only type, but there are others. Say, for example, in relation to guides or escorts, so it will adopt the same standard. It will also be done by subsidiary legislation. It's rather simple because usually you just pay one amount. Please continue. Next is clause 34, change of ownership or control. We have taken reference from 40A bracket 2 of Travel Agent Ordinance. That is, without the authority's prior approval in writing, licensed travel agent must not change the ownership or control of its business, otherwise it's an offense. 35 is in relation to change of ownership or control. There are 7 subclauses. For the first 4, we have taken reference from Section 16 of Cap 218, that is Travel Agent Ordinance. For subclauses 5 to 7, they set out the arrangements of renewal as well as a refusal. We have also taken reference from the Travel Agent Ordinance. Thank you. Mr. Porter. I understand because I know the background. However, when it comes to mainland inbound tour groups, one is required to register and there will be criminal consequence. Is it discrimination because there may be other tour groups charging no fees? You only single out mainland inbound tours and it's rather draconian. So please explain why make this gesture.
Mr. Liu, thank you, Mr. Chair, for your question. For mainland inbound tour groups, why do we need a special measure? Well, first of all, for inbound tour groups, well, actually most of the complaints, over 98% of the complaints, are from mainland inbound tourists. It seldom involves other tour groups from other places. So for these mainlanders' complaints, well, in 2011, it accounted for 11.9% of the total complaints, and in 2015 increased to 40%. So these are about coerced shopping or misled shopping. For mainland inbound tours, it's mainly because the tourists paid 0 fees, and as a result, these tourists are brought to specific places and they are coerced into shopping, and then the tourist guides or the tour escorts would get a commission. So that's why we need a targeted measure. Ever since 2010, the Argent incident, we have seen serious cases from time to time, and there was even incidents in which mainland tourists were attacked and killed in Hong Kong. Well, we saw a serious incident in 2010, and there was another even more serious incident involving a Heilongjiang tourist, and eventually the tourist died. So for incidents like this, they would deal a huge blow to Hong Kong's reputation as a tourist destination. And the impression of people will not fade away after many years. And now from time to time, we still hear people talking about it. And all these are mainly about mainland inbound groups. So we need a better way of dealing with such issues. Because this involves mainland inbound groups. So, of course, we are also cooperating with the China National Tourism Administration. They are very concerned about this, and they support the SAR's government's regulation of these travel agents. Any follow-up questions? Next, Mr. Lok Chung Hong, Vice Chairman. And now that members are queuing up, so I'll give each member 5 minutes. Well, Chairman, I would like to ask about the fee. What's the point of charging the fee? Would the fee go into a compensation pool? I want to know the purpose of collecting such fees. And what's the estimate fee level. Do you charge these on a tour-by-tour basis or tourist-by-tourist basis? And if this fee is really useful, I think you should target mainland tours from certain areas. Well, we have to enforce the law for a very long time. So if you just focus on tours from certain areas, and how about the long run? Shouldn't you treat all the tours the same? And please also tell me about the fee level. Mr. Liu. Thank you, Mr. Luke, for your question. Now, for the fee levels, the TIC is now also charging certain fees. So for inbound tours is registration fee, and for outbound tours is a levy. In the future, the TIA will do the same. That is for inbound and outbound tours. So for the registration fees of inbound tours, now we may make an adjustment because at present the fee level is quite low. We have considered the actual operation of the trade, so we will adopt an incremental approach. So for mainland inbound tours and our outbound tours, we hope that the fee levels would be more or less the same. Now for mainland inbound tours, the registration fee accounts for 80% or 8% of the TIC's income. But for the expenditure on regulating them, it accounts for 38% of the TIC's operation cost. So for outbound tours, the levy accounts for 78% of TIC's income, but for expenditure is 31%. So when it comes to inbound and outbound tours, the fees charged are of different levels. The TIC spends more on regulating inbound tours, but it collects more fees from outbound tours. So we think there is a room for adjustment. But we will adopt an incremental approach. Eventually, we hope that it will be about $200 per tour. But this will take about 10 years to reach that level. We will do it in a gradual manner. Mr. Lok asked you whether you are targeting a certain market. Can you explain to us? Well, earlier on I answered Mr. Paul Chair. For most of the complaints, over 98% of the complaints, starting from 2011, most of the complaints are related to mainland inbound tours. As for other inbound tours, we haven't found such a problem. So we think that our regulatory measure should be target specific. If the inbound tours from other areas are problem-free, we shouldn't target those areas. So we think our regulatory work should be target-specific so that we can deal with the unscrupulous acts in certain markets. Mr. Portier, yes, of course, I understand. Just now, we heard about the Argent incident. Of course, I knew what happened, and there have been a lot of difficulties. For inbound tours, they are getting less and less popular. Most mainland tourists would like to come to Hong Kong individually. So when this piece of legislation is passed, I think things will improve. And we may not need to amend this ordinance for quite some time. But how about flexibility? Can you have a mechanism so that you can add certain types of tours to the subsidiary legislation? Then that would be more flexible. Because now when you look at it, it seems that you are discriminating against mainland tours. Do you think this is feasible? Thank you for your question. For mainland inbound tours, I would like to share with you some figures. Well, after the adjustment, yes, the number of mainland tours has dropped for a while. However, with the passage of time, now when we look at the figure, the number of mainland inbound tours has increased again. In November last year, we recorded a registered number of 400 tours. In early 2016, the trade initiated a non-cooperation movement, and they refused to register their mainland inbound tours with the TIC. So although the registered number was 400, but the TIC told us that there were 20 to 30% of tours that were not registered. So during the peak season, now we found that the number of mainland inbound tours are more or less the same as those during the peak hours in the previous years. Now, during the non-cooperation movement, some of them refused to register with the TIC, and some tourist guides refused to carry their pass. So this gave TIC a lot of difficulties. So that's why we need an official mechanism to regulate them. Mr. Chair asked about other inbound tours. In the future, if major regulatory problems happen, the administration will talk to the trade, and there will be other measures to handle them. Of course, we have to do it through legislation. Mr. Chair is saying that maybe you should have a subsidiary legislation, then you can be more flexible. Thank you, Chairman. Well, we have to legislate anyway, so by then we would know where the problems are, and then we can be more focused on that particular problem, because we need to legislate anyway. But of course, this is a hypothetical question. Now, if there are other inbound tourists that have the same problems, and if it's so serious that we need to legislate, then we will definitely consider legislation. Now, because we want things to be more flexible, if you legislate, it will take several years, but for subsidiary legislation, it can be done in a few months. So, because we want things to be more flexible, and then it will be easier for you to explain why you are focusing on mainland inbound tours this time around. Now, there are tours from different countries, so some travel agents would feel that they are less discriminated against if you adopt my suggestion. Now, for targeting mainland inbound tours, there are different levels. Now, when we handle an issue, certain part of it may need to be handled by primary legislation, some by subsidiary legislation, and some by administrative measures. So we have a three-pronged approach. If we do not need the primary legislation, then it means that it's not such a serious problem, because it may involve financial penalty or even imprisonment. So for mainland inbound tours, we will try our best to do things through subsidiary legislation. Or early on we had a meeting. We talked about license conditions. And now we already have some regulatory measures targeting mainland tours. So this is mainly about operation, and now this will be put under the subsidiary legislation. And for some other issues, we may adopt an administrative measure to handle them. For example, dealing with tourist guides and tour escorts, etc. So if there is a need, we will use the primary legislation. Otherwise, we will use subsidiary legislation or even administrative means.
Next, Mr. Michael Look. I do not agree with the explanation of the Deputy Commissioner when it comes to its logic. You said that, well, it may result in higher compliance cost of the authority. That's why they imposed its particular fees. That is discriminatory. A lot of enforcement agencies incur costs. In the future, these law enforcement agencies may adopt the same logic, saying that certain groups, certain companies maybe should be charged a special fees because of high incompliance with the law. Well, such arrangements should adopt to the same industry and not just a particular group or company, because that is not fair at all. Hong Kong has a very open tourism industry. It may give the wrong impression if you single out a particular market, whether it's our country or not. It wouldn't be good if you target a certain region. I ask the administration to think twice. Well, you only charge them $200 per tour. If you charge the same for other tour groups, will it undermine Hong Kong's competitiveness or appeal? No. And I don't think you need to charge them $200 to begin with anyway. Deputy Commissioner, it's not discriminatory at all. When it comes to regulation, it will only be effective when it's targeted. So measures targeting mainland tours is necessary. And the level of fees charged, we have to look at why these expenses were incurred. As I've explained, the regulatory cost of mainland tour groups accounts for about 34%. However, it generates only 8% of revenue or income, so there is a serious imbalance. Mainland inbound tour groups charge a lower fees. However, the compliance cost the regulatory cost is much higher than outbound tour groups. That's why we think it necessary to adjust the fees. We try to tackle the problem of imbalance in a market. If we, without justification, extend it to other parts, it will be very unfair to other operators. We have taken into account different factors. We do think that this is targeted as well as fair. Thank you. Any follow-up questions, Mr. Look? Next, Mr. Charles Mock. Just a very simple question. I'm glad Mr. Look raised the point of fairness. If it's to be fair, then you can put it the other way round. If you ask tour groups of other places to pay for the extra cost incurred by mainland inbound tour groups. Then it is very unfair. Now the administration proposes a targeted measure. I do think it's appropriate. Anything to add, Mr. Liu? No. Thank you, Mr. Mok. Next, Mr. Paul Tse. I want to change the topic. 34, Clause 34. That is the change of ownership or control. We see a list of mechanisms. It has covered applications, notice, when a decision is made, appeal. But it seems that the tone of 34 is different from 35. 34 says that if there is a change, then it's a criminal offense and subject to a fine at level 3. We understand the responsibility of directors. 34 talks about control. In section 3, you find information about control. This is not a familiar concept. Well, in some large corporations, when the dad retires, then the son will be the general manager. There are quite a lot of such companies when the father just passes the title and the business to the son, and if it is a criminal offense, then I would think that 34 is a rather draconian, that is, compared to Clause 35. We think there is no need to separate 34 from 35 because they tackle the same issue. They are both about a change of ownership or control. It's just that the way it's laid out, it says that if there is a change of ownership or control, you will have to obtain the prior approval from the authorities. It's not the case that it's completely forbidden. Of course, if you don't obtain prior approval, or if the authority refuses the application and you simply go ahead to change the ownership or control, then you commit an offense. This is what 34 is about. Well, since you can make an application to seek prior approval, you need to know what will happen, and it is stated in Clause 35. As Mr. Tse said, without prior approval, it attracts a fine. So in 35, we set out in detail the process involved. There will be a defense if there is a refusal. One can appeal. So 34 should be read together with 35. We have taken reference from the company's ordinance. Of course, we don't rule out the possibility that what Mr. Tse said will happen. And if there are suspected cases, of course, the way we deal with it will be similar to the way we deal with other cases. We will have to gather evidence. and then look at the evidence as a whole, and then for the Department of Justice to decide whether there is sufficient evidence to show that someone has committed an offense, that is, someone has obtained control without prior approval. 34 does not specify a time frame. That is, it doesn't say whether it is permanent or short term. I understand that, yes, we will have to rely on common sense, but it attracts criminal liability, so we have to be very careful. Can you at least give us some clarification, a confirmation that the objective of this clause is not to target a short-term change? Say, for example, when the dad is on long-term leave, the son takes up the baton. Or it only catch people who deliberately ignore clause 35 by not making an application. Of course, it is about a long-term change. Well, you cited an example of someone being on leave, and we need to be understanding. The share structure, number of shares, the structure of the board, and the way staff received instructions. If there is no fundamental change, then I'm afraid it will not be able to reach a threshold of prosecution when someone simply is away from the office for a few days, because the threshold for prosecution is rather high, and that is the same for conviction. It has to be beyond reasonable doubt. And apart from being on leave, Mr. Can you repeat the other point? Well, that is willful breach of the law or repeated offenders by changing ownership without prior approval. Then it's a criminal offense. I think that may be more appropriate. We're not talking about very serious crime. It's just perhaps a case of neglect. We'll look at it later. When we formulate the law, we have taken reference from the way of drafting from other provisions. Of course, if it is deliberate, then it is an offense. But is it the only criterion? The person may say it is not deliberate. We will look at other similar provisions, because we're also concerned that it may create a loophole. We will supply you with information later. In relation to charging registration fee for mainland inbound tour groups, well, it's also a matter of concern. Please put what you have said and put it in paper, your response. Make it more detailed as well. Next, 36. Display of travel agent license and branch license. We have taken reference of 24 and 48 of Cap 218. A few meetings before, we have given you the information. There will be amendments. So, the display of travel agent license at the premises specified does not apply to premises that are not in Hong Kong or premises that are not open to the public. That is, if the premises are not open to the public, even when the premises are in Hong Kong, then then they don't have to comply with this provision. So we will amend it to specify that they apply to premises that are open to the public and in Hong Kong. What if there is a contact address or correspondence address that is in Hong Kong that is not open to the public? So can you should one display the address? Well, if it is not open to the public, then there is no need to display it because it's only a correspondence address. Let's say in an office block, it's an office. It doesn't open to the public. The other one is the home, and it won't be open to the public. But someone may go to the office to make inquiries. It may not be a transaction, just to make contact or ask questions. So should the address of the office be displayed?
Well, under such circumstances, the premises is open to the public, so we think that the license should be displayed. So where do you draw the line? For an office and a home or a place which is not open to the public, how do you distinguish? So even if one person turns up at that place, it will be regarded as open to the public. Well, we will try to be as lenient as possible because we need to protect customers. It's just the display of a license, and this has been an established practice. Of course, if it's a residential place, it won't be open to the public, but for other places, we hope that the license can be displayed. So other than a residential unit, if it's a place for doing business or for operating business, you hope that the license can be displayed. That's the principle, but when it comes to the details, the TIA will work them out. But we want to protect the customers. Now, if a member of the public, not a business partner, can go to such a premises, then to be prudent, we think that the license can be displayed. So are you going to redraft Clause 36? Yes, we will make an amendment to Clause 36 so as to reflect our legislative intent. Now, in that case, maybe you should make it clearer because earlier on it was quite ambiguous. So, in your next paper, please give us more clarity. Okay, Clause 37, display of information about tour group. So this is about licensed travel agents. If a licensed travel agent arranges a vehicle for transporting a tour group, it must display in the prescribed way the prescribed information about the tour group on the vehicle. Now, we want to assist the inbound tours, then they can have the basic information of the Hong Kong tour agents. And when the TIA inspects and investigates, information will be clearer. Well, for the information, it would involve the name of the travel agents, the license number, the tour code number, etc. As to how the information should be displayed and where it should be displayed, there will be prescriptions, and the TIA will make the relevant prescriptions, and we will do this through subsidiary legislation. For 37(2), a licensed travel agent who contravenes subsection 1 commits an offence and is liable on conviction to a fine at level 1. So this is a criminal offence. Mr. Luk Chung Hong. Well, for the contents to be displayed, would the tour escorts information be displayed? For example, his name, his license number, because in the past we have received complaints that some tour escorts are not from Hong Kong, but the tourists didn't know how to make a complaint because they didn't really have the name of the tour escort, or it's just a Mr. Chen or Mr. Lee. So maybe you should also display the information of the tour escort. Well, Mr. Look, the person from the mainland is tour escort, and the person from Hong Kong is the tourist guide. Which one do you mean? Oh, I mean tourist guide. So for display of information in the vehicle, whether the tourist guide information should be included, these are the details, and the TIA will consult the trade. It will look at the actual operation, and it will make a decision. So I think this can be done as just to, well, it's just about the details, right? Yeah, so the information has to be displayed. As to where and how the information should be displayed, the TIA will decide on that. So how about the tour escort? You know, the tourist doesn't know which one is the tourist guide and which one is the tour escort. And sometimes the two roles are played by the same person. So maybe the information of the tour escort should also be included. Yes, that is what I mean. Both the guide and the escort's information should be displayed. So for the local tourist guide, he may ask a helper to assist. Yes, this is what we call a shadow tourist guide. Have you taken this into consideration? Well, the chairman may be clear about this. Well, for a tour escort, he's from the mainland. We are talking about mainland inbound tours, so we are targeting the tourist guides. Well, if a person placed the two roles, then of course the relevant information has to be displayed, and there will definitely be a tourist guide there, and he has to carry his pass. This will be mentioned in Part 3. And also at the front of the vehicle, the relevant information concerning the tourist guide should be displayed, and this will be quite clear to the tourists. And TIA's inspector will inspect the operation of such tours, and it will be very easy for them to identify the tourist guides. So this is about fine at level 1. So will there be a criminal record? Thank you for the question. As to whether there will be a criminal record, it would be decided by the police. It's the same for every piece of legislation. So it depends on the severity of the offense and other factors. And if he's a recidivist, maybe it would attract heavier penalty. So after the bill is passed, we will talk to the police, and the police will decide whether such an offense should attract a criminal record. Clause 37 is just about a fine. As for other offenses, for example, non-franchised bus and taxis, the rules are more or less the same. So for the display at the front of the vehicle, well, if the driver says that this kind of display would mess up his windshield, and he doesn't want you to stick the relevant information there, then what would you do? The travel agents may not know about it. That is, there is no display at the front of the vehicle. So wouldn't it be too harsh? Well, fine is okay, but now you've said that, maybe it would attract a criminal record. So wouldn't it be a bit too harsh? Chairman, we are not on a harsh side. On the contrary, we are on the lenient side. Now for clause 37, when we consider the fine, we have taken reference from other pieces of legislation. For example, taxi driver, they have to display their taxi driver's license, and the fine is $2,000. But the taxi driver is not an employee. Of course, it's when the taxi driver is not the employee himself. For non-franchise bus, the drivers would also have to display the relevant license, and the fine is $3,000, and they may also be imprisoned for up to 3 months. So we have some other similar laws. That is, certain information would have to be displayed. This fine level is already the lowest, level 1, $2,000. So we are not on the harsh side, we are on the lenient side. When we consulted the trade, we have already explained to them about this. Okay, for part 2, any other questions? Legal advisor, I have a question about clause 37. Just now, I've heard the commissioner talking about this. He said that this is to target mainland inbound tours. But when I read the clause, it hasn't specified that. It only said that if a licensed travel agent arranges a vehicle for transporting a tour group. So it's not clear here, but you are only targeting inbound tours. And how about outbound tours? If a travel agent arranges a vehicle for an outbound tour group to go to the airport, would this be included? Now, if vehicles are arranged for transporting tour groups, then the relevant information would have to be displayed, because by doing so, the tour group members would know these information. But of course, most of the problems now happen with inbound tours. But this is not restricted to inbound tours, because if a travel agent arranges a vehicle for transporting a tour group, this clause should also be applicable to them. So for all tour groups, no matter outbound or inbound, even though it's just a local tour, this clause is applicable. Well, for local tours, it's not covered by this piece of legislation. For licensed travel agents, they would also arrange local tours. So that's not included. So licensed travel agents, well, they would have to display the information anyway. Yes. So what's the definition of a tour? If there are just several persons and I charter a vehicle, does it fall within the definition of a tour group? Well, under clause 2, if there's no definition, then we would just look at it from a layman's perspective. If it just includes several persons, it will also be regarded as a tour group. I wonder if the law draftsman would like to add something. Well, in the law, it hasn't stated the number of tour group members, so we will have to look at the actual situation. Then we will be caught by the law very easily. Well, you say this is a tour group, and if the investigator or the inspector thinks that this is a tour group, but the driver doesn't think this is a tour group, then who is to make the judgments? If there are no objective criteria, then there will be disputes. Oh, for this clause, it's about a licensed travel agent arranging a vehicle for transporting a tour group. So there must be a licensed travel agent providing the service. So we have a definition of licensed travel agents and travel business. But still, I think there's ambiguity. Now, if there is a licensed travel agent he gets a commission from overseas or locally, and 5 persons will be transported in a vehicle. He doesn't think this is a group or a tour group, but the inspector thinks that these are 2 families and this is a tour. So where do you draw the line? Well, there can only be 6 members on a tour group. I think there would be a gray area because the inspector would have to decide whether he would sue the licensed travel agents. I think this is a pretty big gray area. Chairman, the TIA will be looking at this. For clause 34, the TIA is authorized to collect evidence. So the TIA will be consulting the trade and administrative guidelines will be issued. Then the trade would know clearer as to when they should display the tour information. Now, for a licensed travel agent, if it provides services to inbound tours, then of course all the tour group information would have to be displayed.
The TIA may issue administrative guidelines to say, well, in this situation, the information will have to be displayed. More information will be given to the trade to reduce uncertainty. Mr. Ao, have you received any complaints or know about any problems they have encountered? Well, that is for the TIC to look to decide. And where there are problems, it will be discussed with the TIC. Well, that means someone will make a decision. So it has to be clearer whether it is subsidiary legislation or administrative guideline. You will have to ensure that there is certainty. Say, for example, several people, they have hired a car that you don't know whether it's simply a family hiring a car or it's actually a travel agent making the arrangements. Mr. Junius Ho. Provision of transportation. I don't know if the law will be broken. And you also mentioned about the definition of tour groups. We go back to clause 5. It's the meaning of carrying on mainland inbound tour group business. 5 says then, well, it says, well, a service providing sightseeing or visits or providing restaurant meals or a service providing local transport. Division 9 is 33 to 37. 33 is about registration fees. So anything under this miscellaneous division comes from clause 5. If you're just talking about a cross-border transportation, so you pick up 6-7 people from the airport to take them to Shenzhen, is it a tour group or just simply a provision of transport service? It seems that, well, if you transport tourists without the display of the information, then you have broken the law. What if it's a service that provides just local transport, even without the display of information of tour groups on the transportation? It doesn't fall under 37, right? First, I'd like to clarify the miscellaneous division. 33 is mainland inbound tour group. 37 is wider. 37 covers all inbound tour groups, or simply put, licensed travel agent. If 37 has a wider scope, well, that it applies to clause 5, that is mainland inbound tour group. And 37 covers not just that, it covers other inbound tour groups. So you will have to look at 4 as well. 4 is inbound tour group business. 41A3, obtaining for a visitor to Hong Kong carriage on a journey that is to commence outside Hong Kong and either terminate in Hong Kong, or obtain for a visitor accommodation. And 5, a service providing sightseeing or visits to local places of interest, service providing meals, a service providing shopping trips, and a service providing local transport in connection with any of the services above. So it's not just inbound tour groups from the mainland. As Mr. Ho said, they will fall under this clause. From my understanding and the explanation of the Commissioner, so if it's just one person sitting in a 50-seater coach or a private car, at the front of the vehicle, then prescribed information has to be displayed. It's nothing to do with the number of people. What is a tour group? If it's one that provides services of meals, transport, sightseeing services, etc. If there is a vehicle with 4 people, it's a 7-seater. The 7-seater will take 4 people to sightseeing, to have meals. Then there should be information about tour group at the front of the vehicle, whether it is from the mainland or from Canada, whether it is inbound or outbound. That's my understanding. You do need to make it very clear, Deputy Commissioner. We will give you more information on paper. Yes, that is more or less what we have in mind. Well, you say that the TIC will prescribe the standard. You will have to make it clear still. And we move on to part 3. Tourist guides and tour escorts. Division 1, interpretation. 38 and 39. Clause 38. Meaning of working as tourist guide. In bracket 2 is a person who works as a tourist guide if the person accompanies a visitor to Hong Kong for the purpose of providing any guiding service to the visitor in accordance with directions of another person who is carrying on travel agent business, whether or not that person is a licensed travel agent. That is the definition of a tour guide. The second one is a tour escort. A person works as a tour escort if the person accompanies an outbound tour group on a journey for the purpose of taking care of the participants of the tour group during the journey in accordance with the directions of another person who is carrying on travel agent business, whether or not that person is a licensed travel agent. Any follow-up questions? For tourist guides and tour escort is under one license. As you know that studies are being conducted under the Qualification Framework. There will be different levels, say for example experience, general and professionalism. Say different expertise, say for example heritage, tourism, green tourism. Does it run counter to this clause? And if there are problems, how do you deal with it? This is the minimum requirement. If you want to work as a tourist guide, you will have to meet the standard. And if you want to work as a tourist escort, you have to meet this standard. When it comes to qualification framework, as the chairman mentioned, there are different tiers. Then it will all be based on this. However, if you reach a certain level, then you can reach a certain tier. That is, you have to first meet the minimum requirements as stated in these two clauses before you can move on to different expertise. They are not mutually exclusive. It's just that, it provides more information. If there are changes resulting in the qualification framework, what would happen? Do you have to change it through administrative guidelines? The TIC may, by way of administrative guidance, set out the relationship between the requirement and the qualification framework. As I said, that these two clauses set out the minimum requirements, so they are not conflicting. Is there a similar standard in other trades? We have taken reference from other trades. That is, we use the law to set the minimum requirement for someone to obtain a license. And then you build on that to move on to other expert areas or different levels of experience. Next, Division 2. Prohibitions. That is, a prohibition on working without license as tourist guide, as tour escort, or not act in accordance with conditions imposed on the license. Failure to do so is an offense, subject to, as we said in Part 2, as a travel agent carrying on business without a license. What about soliciting business online? We don't know whether that person has a license or not. But obviously, it's an advertisement of a tourist guide. How do you stop someone from soliciting business on the internet? If you want to solicit business, that would be the work of a travel agent. Someone engaging in such conduct will have to comply with the requirements, say for example, display of information of the travel agent. So first we have to deal with whether it is an unlicensed travel agent. And when there is a tour group form, then it involves the tourist guide or a tour escort. What if it's an overseas advertisement soliciting business, and then when visitors come to Hong Kong, then there is a tourist guide who works without a license? How do you deal with it? Then we have to look at the facts of the case and the evidence. Then we decide whether we will initiate prosecution. Of course, there will be many different changes. The TIC will, by way of administrative guidelines, set out requirements to ensure that the trade will not inadvertently break the law. Mr. Michael Look. Tourist guides and tour guides and doesn't. Well, are there any different? And some of them work for free. They will just go to show people places with special interest. Because this may be a way of creating job opportunities. It promotes special tourism of special interest in Hong Kong. So do these people have to have a license? And there are also people who work as a docent, but they do everything as a tourist guide does. So is there a gray area? So will you differentiate the difference between docent and tourist guide?
Mr. Liu? Thank you for your question. Well, for the services of tourist guide, we have made them very clear. Now, well, there will be another person operating a travel agent, and this travel agent instructs a person to provide information to tourists, to provide sightseeing service, to take them to places of interest, etc. So this would involve the business of a travel agent, and this travel agent instructs a person to work as a tourist guide. Now, if there is no travel agent, and if another person is instructed to explain to the tourists about certain things, for example, it's a museum, then there will be another issue. So no matter whether the person is paid or he does it on a voluntary basis, even though he's acting like a tourist guide, he is still not a tourist guide. So if a travel agent instructs a person to take tourists to a museum, then that person will be a tourist guide. I think the distinction is quite clear. No follow-up question. 41. Well, for clause 40, no person may without a tourist guide license work as a tourist guide. 41. Prohibition on employing or engaging person without license. We have taken reference from 39(1) and 55 of the real estate agent ordinance. So you can see here that persons without license cannot be employed or engaged. And if it's a breach, is liable to a fine at level 5. Well, there are some intermediary travel agents. Now, if it is not a licensed travel agent, well, it recruits tourist guides, and such tourist guides will be used by travel agents. Some of these tourist guides are not licensed. So how would you handle that? I think we have answered this question earlier. So this is about the travel agent, whether it is licensed and whether it's carrying on this kind of business. So if it's an intermediary, if it's not a travel agent, then it's an employment agent. So it's different. But if it's a licensed travel agent, and if it hires a person without license, then it will be caught by Clause 41. For an intermediary, if it just refers people to the travel agent for use, then the travel agent is using the service of this intermediary. But, well, for the intermediary, if it's not a travel agent, of course, it would not be regulated by this piece of legislation. However, the person, well, it will refer people to the travel agent. But if the travel agent uses these people which are not licensed, then the travel agent would be caught. So, okay, there is an intermediary and it hires unlicensed tourist guides, but it's not a travel agent. And also the tourist guide is not a licensed one. Then which piece of legislation does it involve? So you're talking about local tours. So if there are tourists from other places, then it would cover inbound tours. But of course, if it is a tour organized by an OC, it is different and it's not regulated by us. How about a teacher? If he takes a tour to a certain place, then what would happen? Because schools may organize outbound tours, as long as he's not hired or instructed by a travel agent, then the teacher would not become a tourist guide or tour escort. Okay. Division 3, licensing. It starts with Clause 42. Clause 42, application of tourist guide. I have another question. Now, for a non-licensed travel agent, it hires guides and escorts, and the guides and escorts do not know that the travel agent is not licensed. So you mean that the guides and escorts have licenses, but yes, but the travel agent is not licensed. Of course, the guides and escorts would not have to bear the responsibility. Because it's the travel agent that's not licensed. So the responsibility lies with the travel agents. Clause 42, application of a tourist guide license or tour escort license is similar to Part 2, the part concerning travel agent license application. Clause 43, issue of tourist guide license or tour escort license. Subclause 1, the authority may, on application, issue a tourist guide license or tour escort license to an individual. This is similar to that of the travel agent. As for Clause 2, the authority has to be satisfied with certain conditions before a license can be issued. It's more or less the same as the factors that are considered by the TIC. Now, for example, the person should hold a permanent ID card, holds an ID card that is not subject to any condition of state that prohibits the applicant from working as a tourist guide or tour escort. The applicant has reached the age of 18 years. The applicant is suitable to hold a license. The applicant has a valid certificate of competency in first aid, etc. And for subclause 5, the applicant meets the education requirements set out in Schedule 8. And let's look at Schedule 8. Now he has to finish 5 years in secondary schools or in the new senior secondary academic system. He has to reach a certain level, so he would have to meet these requirements. So Schedule 8, if that person studies overseas, he has to make the TIA satisfy that he has met the education requirement. So this is about Schedule 8. I want to ask about bracket 2.7. The applicant has completed the pre-examination training courses specified by the authority. So do you have to specify the courses? Well, the TIA would have to specify, and the TIA would have to do it administratively and tell the public which courses administered by which institutions would be eligible. So this would be done through administrative instructions, because there are changes all the time and the contents of the courses may change to meet the demands of the market. So we think this kind of arrangement is more flexible. So is it the same as what the TIC is doing? Well, we intend to do the same. That is, the arrangements are the same. Legal advisor. For clause 43, I would like to ask a question. 43 bracket 2 A4. The applicant holds a valid certificate of competency in first aid or another similar certificate. So for the similar certificate, must it be issued by a prescribed institution? The TIA would prescribe the institutions. It would have a list of institutions which are eligible. If that is the legislative intent, then I would like to refer you to the Chinese version. Well, because for the English version is very clear. It's like what you said just now. That is for the similar certificate. It has to be issued by an institution specified by the authority. But in the Chinese version, it's like the 申請人持有該國指明的機構發出的有效急救技能證書。And then it's followed by a comma and goes on 或其他類似證明書。So the certificate has to be issued by a particular institution. It's not very clear. I think if you add a comma there, it would make the meaning quite unclear. So maybe you should delete the comma. Understood? Any supplements? DFJ would like to thank the legal advisor for her advice. Well, here you talk about an institution specified, but in another subclause you do not include this specified institution. What's the difference? It's just a way of presenting it. Well, for first aid courses, generally, they are accredited by certain institutions. But for pre-examination training courses, it's more flexible. So we would use course as a unit. We hope that more institutions can provide this kind of service. So for first aid, because it's more professional, so you need to specify the institution, right? Yes, for first aid courses, they are provided by professional institutions. So the authority would have to specify the institutions to make sure that the certificate is up to a certain level. But for pre-examination training courses, they can be provided by different institutions. Yes, understood. Okay, let's go on. Clause 43 is also about fees, the formats of the license, etc. So these are similar to Part 2, and the wordings are more or less the same as those for travel agents. For subclauses 6 and 7, it's about the validity or validity period. This is a bit different from that of the travel agents. So for tourist guide license and tour escort license, the validity period is 36 months. It is the same as the passes issued by the TIC now.
Will there be a transitional period like a driving license? Like a grace period? Say, well, within a certain period of time, you may, after the expiry of your license, you can still apply for a license, but after that period, you may not. Well, 47 is about renewal. I will be able to give you more information when we get there. 44 states what tourist guide license or tour escort license authorizes. We have taken reference of clause 11 in relation to travel agent license or branch license. If there are no questions, I move on to clause 45. If the authority intends to refuse to issue a tourist guide license or tour escort license, it must by notice in writing given to the applicant. It also states the notification period. In Part 2, refusal to issue travel agent license or branch license, you will find similar provisions. That is clause 12. It says by notice in writing. How is it served to the parties involved? By post or what? Well, usually it will be by post or registered mail. That will be an administrative arrangement. 46 is application for renewal. There is a procedure involved. It's similar to clause 2. Clause 14, application for renewal of travel agent license or branch license. 2A. Well, they are similar to this one. Well, you will find the requirement similar to travel agent license or branch license. The renewal procedure, you can refer to the schedule. There is one that applies to renewal application for license, tourist, travel agent license or branch license. So you may refer to 1(2). That is, application for renewal of tourist guide or tour escort. They will have to be made within a certain period of time. That is, if an application is made before the expiry of the license, then it has to be made within 3 months of the expiry. B, if it is after the expiry of the license, then it should be within 2 years. That's in Schedule 1. Well, you talk about a professional development plan for tourist guides for a certain number of hours. For guides and escorts, yes, they have to have professional development courses, and details will be mapped out by the TIC. So the TIC will decide on these courses without consulting anyone. Well, if you take a course on wine or local tour, then they all count as continuing professional development. So what will be the arrangement be in the future? It won't be decided unilaterally. There will be 4 groups of stakeholders. The TIC, who is the regulator, guides and escorts, practitioners, and travel agents, because they are employers of guides and escorts, and also training institutions. We will collect as many comments as possible to make sure that these courses are useful. 48. Refusal to renew tourist guide license or tour escort license. If the authority intends to refuse to renew a tourist guide license or tour escort license, it must, by notice in writing given to the applicant. We have mirrored the provisions in Clause 15. That is, those that applies to travel agent license or branch license. 49 and 50, the wordings are similar. 49 is in relation to tourist guides and 50 tour escorts. Applicant for tourist guides or escorts, those who apply for renewals, however, if their applications have been refused, then within a certain period of time, these people may not make another application. There are similar provisions that applies to travel agent license or branch license, that is Clause 15. 51, 52 is another pair. 51's for tourist guide, 52's for tour escort. If the license is revoked, then within a prescribed period, the person is not permitted to reapply. We have taken reference from similar provisions of travel agent license. You may refer to Clause 17. Now we move on to 53. When the TIC considers whether a person is suitable to hold tourist guide license or tour escort license, you will find details in Schedule 4. We can please refer to Schedule 4. It is in relation to individual matters. We have looked at similar provisions in relation to travel agents. That is, we will consider whether someone is a discharged bankrupt, whether someone has committed criminal offenses, whether someone is mentally disordered. Well, you see that there, under 2, for the purpose of Section 53, we will consider whether the individual has been convicted, whether in Hong Kong or elsewhere, of a criminal offence involving sex or drugs. That is an additional provision compared to travel agents. That is the last clause in Part 3. So, is it similar to TIC requirements? Yes, consistent with the requirements of TIC currently, because guides and escorts are frontline practitioners. If they have been convicted of, say, violence offence or sex offence, that will be taken into consideration. Have you encountered any problems when it comes to enforcement by the TIC? They have not told us about any problems. I believe it has worked well. Any follow-up questions? If not, we move on. Part 4. General provisions relating to licenses and licensees. Clause 54, duty to comply with prescribed requirements. It stipulates that licensed travel agents, guides and escorts will have to comply prescribed requirements set down by the TIC. We have taken into account the existing 14 and 48(2) of the Travel Agents Ordinance. The current practice is that through subsidiary legislation, in the future, the TIC will be empowered to, by way of subsidiary legislation, stipulate requirements that they should comply. On top of that, penalties will be stated as well. We think that the TIC will adopt similar requirements of travel agent ordinance. In relation to tourist guides and tour escorts, well, although there is no urgency to have these requirements set out, we do think that the TIC should be empowered to prescribe these requirements so that where needed, they can be put in place through sub-leg. Well, for sanctions, one is disciplinary sanctions by TIC, the other one's the court. So when you refer to these contraventions, you're referring to court? Yes, for 54, 2 and 3, they relate to the court. So there will be several sanctions, first by the TIC before the case goes to court. So that party will be penalized twice. No, because well, there are corresponding penalty provisions to different offenses. We put this in place just to cater for future needs. Say, for example, there are different situations, new problems. Then, through prescribed requirements, licensees will have to comply. And these requirements will be put in place by subsidiary legislation. The LegCo's approval will be sought. So there is a chance of someone being penalized twice. Say, a breach of requirements of the TIC, the licensee is penalized. And then the case goes to court. The court will dish out penalties. Let me put it this way. For the same conduct, whether it will attract criminal offense and an administrative breach. Is that your question? Yes, it may happen. Well, TIC deals with similar cases as well. And when this happens, well, first there will be investigation into criminal liability, because it is more serious, so it will be dealt with first. The regulator will have to wait for the criminal investigation to complete before considering the breach and the administrative procedure.
For example, if a travel agent violates the trade description ordinance and is convicted, then there may be penalty, may be imprisoned, or there may be financial penalty. And for the regulator, of course, this is also a breach. And the regulator may suspend or revoke the license of the travel agent. So for regulatory regimes, they are more or less like this. First, you look at the criminal offense, and then followed by disciplinary actions. Now for the TAR and the TIC, they work differently. Well, for TIC, I think the highest fine that has handed out was $900,000. Here, of course, it involves criminal offenses, and the fine may be at level 3 is $10,000. Then, of course, the travel agent would prefer going to the court than to be disciplined by the TIA. Because the TIA will, the TAR will be subsumed under the TIA, and it works differently from TIC. So this may happen. Our TIC's fine levels may be high, and the highest level was up to $900,000. So how do you strike a balance? The levels of fine are very different. Mr. Ao? Well, for the TIC, it regulates its members. And for the TAR, the Assistant Commissioner told you what we are doing now. In criminal investigation would go first. When there is a result, TIA will handle the case. So if the criminal offense is convicted, then the highest penalty would be the revocation of license. So this is the present approach. So in the future, TIA will be dealing with the licensed travel agents, and when there are breaches, will the fine levels be lower than that of the courts? If that is the case, then it will not be deterrent enough. Chairman, I would like to supplement. First, the TIC, as you mentioned just now, well, the fine will be up to $900,000, and that's not about one offense. That's the accumulated amount after repeated offenses. So each breach would be subject to a penalty. So it's just like illegal parking. If there are several occasions of illegal parking, of course there are several fines, and the accumulated amount of fine can be higher. No, that is not accumulative. It's of different scales. So yes, of course it will depend on the severity of the offense. And now we will use subsidiary legislation, and as a result the fine level will be lower. But for serious cases, the fine levels will be higher. And for the ceiling, of course, the court would look at the number of times that the travel agent has committed the offense. As for criminal liability, as the chairman said just now, sometimes the culprit is not only penalized by a fine. There are different provisions here. Offenses may also attract imprisonments. So the deterrent effect would not be weaker. So when you make a comparison, the deterrent effect is indeed not low. Well, for example, if I were a travel agent and I'm fined $500,000, I don't know whether your future approach will be like the TIC. Well, there are different levels. Level 5 is can be hundreds of thousands of dollars. So I'm not talking about cumulative amounts. If I were a travel agent, the TIA penalized me. Well, if I have committed this offense several times, and if the highest fine is $500,000, and I'm not satisfied with it, and I go to the court for an appeal, the court thinks that yes, I've breached the law, but the fine is only at level 3, and it would only be $10,000. So that's $500,000 on one side and $10,000 on this side. Well, for TIA, when it considers the level of financial penalties, of course there are different factors. We cannot compare this with TIC because TIC doesn't have the relevant provisions. So for TIA, well, we'll look at things comprehensively. As for the administrative fine level, that will be handled administratively. But we understand the chairman's concern. We believe that the level eventually decided on will not be less deterrent than the administrative one. Well, for TIC, when it comes to serious cases, the penalty would also be heavy. So when we decide on the financial penalty level, we will definitely take the severity of unscrupulous act into account. The TIA may decide on a certain level of fine, and the courts may decide on another one. But I think the cost fine level should be higher. So can the travel agent lodge an appeal? Now the court imposed a fine at level 3 on him. Then would the TIA's fine be rendered invalid, or are they different? Both bodies can impose a fine on the travel agent. Yes, those would be considered separately. Criminal liability is different. So if the criminal offense is convicted, then the breach would be regarded more seriously. But this would be handled independently. First, the criminal liability would be looked at, and second, the non-compliance part would be considered by the TIA. Ms. San Chung, I wonder if the administration has these figures. How many licenses have been revoked in the past? Or how many criminal convictions have there been? Mr. Ao, you have the figures? As for court convictions, I don't have the exact figures with me now, but in the past few years, each year there were several cases. As for revocation of license, the number is not high. So on the average, 1 or 2 cases a year. That is about the revocation of license. Now, if a license is revoked, would the travel agent apply for another license? Have you seen this before? Thank you for your question. Yes, we're also very concerned about this. So when we look at the application for a new license, we would consider a lot of things. Ms. Zhang's concern is also our concern. So we would tell the license applicants that it will take us some time to do the investigation. We need to do very careful vetting. We won't allow the same group of operators to apply for a new license under another name. We are very concerned about this. Mr. Liu? Yes, in this piece of legislation, we are also targeting this problem. That is, there will be a guarantee fee of $500,000. Now, even though they change the team, you don't recognize the relevant people, but if they want to apply for a new license, the cost is much higher. We hope that we can effectively target this kind of act. Well, Chairman, the directors of companies or listed companies might have breached certain company laws, and then they are penalized, and for a certain period of time they cannot be appointed as directors again. And even when a person goes bankrupt, that is this kind of rule. So for a licensee, if it's convicted of a criminal offense, he can apply for another license. So this is my concern. Even if you have a relevant measure in place, he may have a countermeasure. He may ask a relative to do this for him. Now I have another question. Well, we are already at 10:30. I'll extend this meeting by 5 minutes.
Just now I heard that under existing legislation, the TIC, well, it will be the registry that will revoke the license, and the TIC will fine or revoke this membership. Without the membership, they cannot get a license. It seems that it is about the same thing. Penalized twice. Does it mean that the TIC can penalize the agent once and then another time by the court? Perhaps so. The agent will be penalized twice. No, it is not like that. The same conduct. There is the criminal liability, usually is more serious. Say, for example, forced shopping. An offense is committed. Of course, the court will deal with it. The public may ask for disciplinary action because the court will impose imprisonment or fine, but the agent is still licensed and will continue to operate. Of course, the public expects that that will be dealt with. So the licensing will be dealt with by administrative measures. Currently, it is by revocation and fine. In the future, it will be the same, directs as revocation of the license and or a fine. This will be an appropriate way to deal with a serious misconduct that will meet public expectation. Thank you. Let me ask one more thing. So, you'll have to wait for a court decision before the license is revoked. It's about the same action, same conduct, committing an offense and a breach. There are other conducts that breaks the law without breaking the requirements. If it is the same conduct that breaks the law and breaches the requirement, well, it applies to all regulators. They will have to wait for the offense to be dealt with first before dealing with the breach. So you have to wait for the court's decision. Or is it the case that, well, the TIC has already made a decision that the law is broken? They will just ask the court to deal with it, and the agents will continue to operate? No. if an offence is committed, the license may be suspended first to await for all evidence and information, and then there would be fine and revocation. So the TIC has the right to suspend the license. Yes, you don't have to wait for a court decision. So the TIC doesn't have the power. Yes, they do. It's just that it's separated between the council and the registry. In the future, it will be the TIA and the court. There is no other business. The next meeting will take place on the 19th of March at 10:45. I ask members and government officials to be present. Thank you. Meeting adjourned.